Did your contract accidentally create a partnership? That's the question I'm going to be talking about today. I'm Aaron Hall, a business attorney in Minneapolis, Minnesota. A partnership is where two or more people carry on a business with the intention of sharing profit, essentially as owners. But what happens is you can find parties are accidentally in a partnership, a de facto partnership, if you will, without ever realizing it. And here's the problem with a partnership. In a partnership, both parties are liable for the acts of the other. They are personally liable. So let's say, for example, that John and Kim decide they're going to sell lemonade together. And they both pool their money to buy lemons and sugar and water and a little lemonade stand. And then they decide that any of the profits they'll get out of it will be split. They didn't go register a partnership. They didn't go through any formal process. They didn't sign a partnership agreement. The question is, are they a partnership? Well, very clearly they are. And here's why. You have two or more people who are doing business together with the expectation of sharing the profits. That's a partnership. It's a de facto partnership. It's an accidental partnership. That means that if John leaves and Kim stays there, and Kim accidentally hurts somebody, maybe she drops the lemonade pitcher on a baby in a carriage and the baby is hurt, the family of the baby can sue Kim and John because they are both personally liable for the acts within the business. That is why an LLC or a corporation is so important. Where multiple people are going into business together, it's especially important to have a limited liability shield. That separates liability of the business from the liability of the individuals. Here's how that works. If John and Kim set up a corporation or a limited liability company, also known as an LLC, then John and Kim would not be liable personally for the acts that happen within the business. Now, if Kim was the one to accidentally drop a pitcher of lemonade on a child and the child was injured, Kim would be responsible for her own acts. You're always responsible for your own acts or your own negligence. But John would be protected from liability because in an LLC, liability is limited. Only the company is liable. The individual owners are not. Similarly with the corporation, you have a limited liability shield or veil in a corporation. And unless you've done something to violate that limited liability veil, you are not personally liable. Now you might be wondering, what could you do to violate that? Well, the most common example is commingling funds. In other words, your personal funds and your business funds are commingled. You're treating the company's finances like your personal piggy bank. That's a great example of where even though you have a corporation or an LLC, the court will say, look, you didn't respect the formalities of having separate finances, so the court's not going to respect the separation that would normally be available between a corporation and a shareholder. So, back to the topic. Can you accidentally find yourself in a partnership? Absolutely. It's called a de facto partnership or an accidental partnership. What about two businesses that are working on an event together? That is a great example of where businesses can accidentally find themselves mutually liable for each other's acts. So there you have it. That is an accidental partnership. To learn more, see the description below. There's a URL linking to my article at aaronhall.com. Please keep in mind that I do these educational videos as a public service to help you spot issues, to talk with an attorney. But this shouldn't replace talking with an attorney. And that is elaborated on more in the disclaimer below. If you want to hear more videos like this, you can subscribe to this channel or sign up for our email list. Again, I'm Aaron Hall, a business attorney representing business owners in Minnesota.